Welcome to Law Media. Thank you so much for allowing us to serve you with truth, honesty, and perseverance. My name is Sarah, and I'm going to be your host today. And I wanted to come on and talk about qualified immunity and exactly what that is and how it interacts with what's going on right now. So, as we approach the Thanksgiving holiday, we have seen an onslaught of violence, protests, killings, destruction of private property, riots this year. Things really kicked off with the George Floyd killing. We had the Breonna Taylor protest, the Ahmaud Arbery slaying, just a lot of acts of violence from state actors. So, when we get ready to combat police brutality, one of the main hurdles that we have to get over is qualified immunity. So, qualified immunity is basically, to give you a gist, it basically says that police officers are immune from being prosecuted for their actions. It is a judicial created remedy. That means Congress never said, hey, we're going to apply this qualified immunity blanketly across the nation. It is a doctrine that the Supreme Court uses to determine whether or not a particular police officer can be tried individually. So, this doctrine basically is a two-part test. First, there has to be enough evidence or a showing that a police officer acted unlawfully. That one isn't that hard. It just has to be enough evidence that can convince a jury. But then we have the second test. The second prong of this test says that a police officer either knew or should have known that that particular conduct was illegal because of clearly established law or a clearly established case that says that dictates that particular conduct to be illegal. In layman terms, basically you have to overcome qualified immunity, a plaintiff has to show that A, there was or there is evidence of unlawful conduct, and B, the officer should have known that that conduct was unlawful because a court said that this specific conduct is a civil rights violation on whatever date. And that's what we call precedent. What the court said last time, and we are going to stick to precedents. That means that's stare decisis. That means let the decision stand. If this is what the court said at that particular time, well, we're going to follow it. Stare decisis. The decision will stand. So, in order for a plaintiff to show that a police officer acted outside of his duties or that a police officer violated the law, we're going to have to find a case in which a judge said, under these circumstances, this cop violated the law, so the cop in question who has committed a similar offense violated the law. And that is hard to show because courts aren't viewing it in a way where they're looking for similar fact patterns. Courts are looking for the exact same fact patterns. One of the cases that I read, the decision was, or the stare decisis basically said that allowing a dog to attack a suspect while he sat on his hands is illegal and unconstitutional. But another court said, well, if the guy's hands were up, that's not the exact same thing as him sitting on his hands, so that act is not deemed unconstitutional. So, how do we combat this? I think it's the personal opinion of Law Media that we just need to bring more cases. If there aren't a lot of cases that are discussing exactly what is legal and what is not illegal, I think it's our duty as citizens, as individuals, to bring those cases and let the courts decide. We're going to need that precedent for future cases, and we're going to need that precedent as we combat police brutality. So that is the first of what I think we should do. Thank you guys so much for tuning in, and I'll see you next time. Thank you for choosing Law Media, and happy holidays.